Tenio, aye.
Clark, aye. Just for everybody in the audience and online, this meeting is being recorded. Okay. We're gonna go right.
Can you guys hear me?
Yeah, we can hear you.
I'll read the agenda.
Go ahead. You there, Swati?
Yep, all good.
Have you read the minutes?
Yes, I did. I read the minutes.
Motion to
Next.
accept.
I love it. I don't know the date.
August 21st.
Make a motion from the minutes of August 21st.
See a second from anybody. All in favor, say aye.
Aye.
Clark, aye. I see Bonnie raising his hand. Aye, great. Okay, minutes accepted. Get right into hearing.
And I have a paper copy of the stat application as well.
All right, in accordance with NGL Chapter 40A, Section 15, a public hearing will be held on October 16th, 2025 at the Mendon Town Hall at 6 p.m. Just duly noted that it's 6:25, just due to some technical difficulties. Applicant owner Semi Lisa is appealing the building commissioner's decision dated July 11th, 2025. Regarding the storage of commercial vehicles at 20 Bignell Drive, parcel 9-102-20. Who's here representing the petitioner?
Running for the petitioner, and it's Semi-Wiser and Mercurius LLC. So both owners of the property.
We have the building commissioner here, John. Would you like to speak and tell us what you've seen? And
yeah, I mean, there's been an ongoing number of complaints at this property going back to 3 or 4 years. When I initially received the complaints, I went and investigated. Mr. Weiser said he was in the process of moving in. This was, I think, December. He was moving in January. At the time, he more or less only had 1 or 2 commercial vehicles there.
Yeah.
He told me he was going to be living there. And a relative lived in the 2-family house, a duplex style. And a relative lived in the unit next door. They both worked for the landscaping company, and they were simply driving their vehicles home at the end of each day. They weren't really using it for any, I would consider, commercial activities or prohibited activities. It was just accessory to, the single family use. Prior to realizing that he intended to live there, I did cite him for running a business there where he lived in Milford and was storing his commercial vehicles at the property. When I found out that he lived there, it changes things. That's just there. That's typical accessory to the single family use or the 2-family use. Over the next couple of years, I received more complaints from several different neighbors. It didn't get to the point where I thought it was truly a commercial use. It was approaching that, and this has been a gradual growing intensity of that commercial use there, to the point of this summer where I inspected it, and you have a number of pictures, I believe, in the package that shows 2 or 3 commercial trailers, 2 or 3 commercial vehicles, small dump truck type vehicles, a couple of commercial sanders, commercial plows, dozens and dozens of shovels and rakes and hand tools, Home Depot buckets. I don't know what was filled in with that, but it certainly didn't seem accessory to the single family use. It certainly seemed like he was running a business there, not unlike other businesses that we've ordered to cease and desist, notably one on Maury Street, which was a hot button topic a few years ago. It's just, to me, it's a blatant commercial use. He's running a business out of there. He seems to be bringing some materials back. His explanation is that he's getting it from the job sites and he's just cleaning up his yard. That may be the case. It may be the case that, he's using it to dispose of. That's not really my primary concern, but when you add it all up, there's employees coming there from what I have for reports. And it might be notable that, all these photos were at a day when Mr. Weiser and his brother-in-law, or whoever his relative is, they weren't there. So presumably they were in 2 other commercial vehicles. That's kind of irrelevant because this was egregious enough for me to issue that cease and desist order. His attorney reached out and asked if because I had given him to get the time period, he asked if he could have the full length of the appeal period to decide what he was going to do, which I was fine accommodating that request. And here we are now because somebody was unable to make it at, I believe, the September or August meetings of all.
Okay. And like to hear from the petitioner?
Yeah, thank you. So as I know, my name is Brendan Cook. I represent the owners of the 20 McNeil Drive, Cruis LLC, Cruis and Sam Wiseau. You know, the board, I believe, is familiar with this appeal because it's been sent up here. This is now the fourth time. Mr. Erickson noted that the first complaint for this property was December 2022, so this has been going on for a little while. And it started pretty much immediately after my client purchased the property, or my clients purchased the property in October 2022. So there was actually an appeal of Mr. Erickson's previous denial of an actual refusal to enforce the zoning code of the same essential premise. So that was heard, or I believe was submitted to this board on September of 2023. I believe it was September 5th, but slightly different date. But it was actually heard 2 years ago in October 19th of 2023. And if you look at the materials that were submitted to the board with that application, that request to essentially take enforcement action and overturn Mr. Erickson's decision not to, the activity is identical to the issue that's before the board right now. There were 2 commercial trucks there. There were a handful, 2 or 3 small trailers, essentially used to move different equipment around the yard, as well as connection with the landscaping business. The hand tools, the sanders, the snow plows. If you go through the pictures that were submitted to this board in 2023, the complaints right now, and the board ultimately decided that keeping the pickup trucks to the property were not a commercial use. Keeping the tools that were cited and shown in the pictures was not commercial activity under zoning bylaws. Subsequent to that decision, it was not appealed under Chapter 48 to the Superior Court. But there were subsequent appeals, essentially, abutters would request, enforcement from Mr. Erickson and appeal that decision, even though it was underlying the same issues that commercial activity complaints. So there were appeals submitted to this board in, I believe, May of 2024, as well as November of 2024. Again, the same basis that this board denied, the complaints of commercial activity at the property. So essentially what we're asking for is for the board to stay consistent with its prior holdings in that there is no commercial activity going on because there is no change in the activity that's gone on from the board's prior decision that there was no commercial activity. I cited some case law in my notice to feel it's been submitted to the board. Essentially outlined the doctrine of issue preclusion here in Massachusetts, and there is preclusive effect to prior zoning board of appeals decisions, especially when they're not appealed to the Superior Court for further review. But essentially, again, we're asking for a consistent holding being placed on the same property for the same use. And I understand Mr. Erickson, he's responding to complaints that are being submitted to the property. They're numerous and they're pretty constant, to be honest. There's been complaints not only submitted to the building department and this board, but also the Board of Health regarding barrels that were outside, the spurious allegations of hazardous material that was mislabeled, allegations of brush fires to the property that the fire department had to respond to, which were found to be unfounded. Just really like an ongoing enforcement campaign against this property. I'm not entirely sure what the motives of that are. But to me, it seems inappropriate that the town would act as essentially private enforcers for abutters who don't like looking at trucks parked outside of the property. And then on top of that, there's been some disappointing allegations thrown about regarding drug use of the property, trash that's being thrown, devaluing abutting property owners. Again, to illustrate, sort of things my clients been dealing with in being accommodating to the town. I'd like to highlight that, whenever anybody responds, whether it's Mr. Erickson with the Board of Health or anybody else from the town of Mendon, comes out to the property, they're welcome onto the property, they're welcome to have a look. They're taken around, they're spoken to, they're explaining what's going on. We're not trying to hide the wall here in any way. Again, essentially what we're asking for is for the status quo to continue, and to confirm the board's prior findings of what's gone on the property and essentially how that's consistent. And just to close on that, recently or throughout the enforcement requests that have been submitted on this property, there's actually been drone incursions on 20 McMill Drive at a frighteningly low height. It seems to be by the picture submitted that the drones are flying at building or window height on my client's property. And again, that's really just to illustrate the kind of ongoing surveillance and campaign for enforcement against my client and what they've had to deal with in this. So again, I highlight that there's been previous decisions made. The use is still consistent. I know Mr. Erickson highlights that there was materials brought to the property from job sites, but it was used at the property. I believe Mr. Erickson's been back out to confirm that material has been spread around and is no longer sitting there. My client doesn't have customers coming to a mulch yard in his backyard where they're picking up product. Essentially he's taking his truck and equipment as anyone would with, any kind of work-related material from their house to a job site. There's no customers coming, there's no one being enticed to come to the property for commercial transactions. And just to highlight that, I think the board's prior decision was correct in that this isn't commercial activity, right? It's essentially an owner of a property using it as a residence. It's Mr. Weiss's business partner that lives in one side of the duplex and a tenant in the other that does work for the company. So they're using the equipment at the place they live and bringing it to job sites. And again, there's no commercial activity going on at this is no different than anyone else leaving their house to go to their work site, their job, and materials they need to do that. So with that, I press on the notice that I've submitted to the board. And, I'm happy to answer any questions or respond to anything the board.
Yeah, if I can, Mr. Chair. What I would say is, what my observations were this past summer are different than what I saw 2 years ago. I didn't go look at the same conditions and suddenly change my mind. The use has intensified every time I've gone there, and it got to the point where I felt that this is a prohibited activity. It's not the same as it was in 2023. I based my decisions on what I saw in person, not on photos submitted by anybody else. I took my own photos to submit to the owner of this property. So it is just drastically different than it was when I first went out there. And if you were to uphold my decision and he takes 2 vehicles there, I'd be okay with that. If he continues with everything else, the other large scope of this, I would I'd take further legal action.
So, yeah, I think the previous observations, we pretty privy to that. We read the pictures and, we talked with some of the abutters, and the building commissioner did side of finding that, there was no real commercial activity, but, it's testimony that there's actual physical activity. It's not just a matter of a few trucks. It's actual activities, workers coming to and from the site. It's staging building construction materials at the site for presumably use elsewhere or on site, but I don't think you're using sanders on site. There's 2 or 3 of those. That's for.
Well, I've been by there a few times before the last appeal, and I've go by there 3 times in the last 4 or 5 days. The site does look different.
Yeah, I mean, the pictures,
Years ago.
there's a lot going on there in the pictures.
If I can just add, the whole point of tonight is what I cited him for back in June or July, not, maybe he did mitigate some of the, activity, but that would be great if he did.
And recognize the Gentleman in the back, name and address, please.
Brian Levy, 59 George Street. Our property abuts Sam's property. Basically my backyard abuts his backyard. He hauled in material, flattened out his yard. I would say that would be the excess of what you're saying as different. There's a couple trucks comes in the yard, it's parked in the back, not out front where you could see him from the road. If anybody has a problem, it would be us. Yeah, there's a standard there. I mean, I don't see any employees coming in. I don't see any commercial stuff being done. I just see somebody bringing in their trucks, parking them at night, and then leaving in the morning, coming back.
And who is that someone that's doing that?
I don't know. I don't see who gets in the truck. I just see the trucks are gone in the morning and back in the afternoon.
Well, I think it's building inspector's observation that those are employees of some company that are.
I don't see it. I don't see anybody parking their cars on the street like employees pulling up and parking.
What I would say is whether that's happening or not, I still consider this a pretty significant commercial activity. Anecdotally, I've been made aware that there's employees coming. If there's not, that really doesn't have any bearing on my decision.
But if I might just address that point, then I think it's important to go back to the photos that were submitted in 2023. I mean, those can't lie. They'll tell you what the activity was then versus now. And the items that are being complained about now in the decision at the hearing, those items were there. The trailers, the sanders, the snowplows, they're depicted in photographs. Right. So if that purely is the issue, the presence of those items on the property, this board's already decided that. It's not commercial activity. It's accessory use to a residential structure. And again, the current residents there are somebody who works for the company and rents the space and the owner of the company who lives on the other side of the duplex. So it seems like the rationale that's applied through 4 years of this is going to continue to apply. And I would point that in my notice, I've highlighted other properties in Mendon that have this exact same setup going on. That nobody's taken enforcement action yet. You know, in that there's trailers, there's, landscaping companies registered to that address, trailers, buckets, hand tools that are present, invisible from the street. So implicitly, the town has found that that's an acceptable accessory use in the rural residence district.
Yeah,
It exists.
There may be other, properties that require some enforcement that there's no bearing on this matter at hand. There's a substantial amount of complaints that have, pictures, the testimony of, firsthand account of the building commissioner that there's commercial activity. The pictures contracted, it's commercial activity. Oh, if you want.
Well, I point out that there's 2 abutters that have complained and 1 abutter's here actually testifying that some of those complaints are unfounded. There aren't employees coming and going. They're not coming at, all hours of the night.
But the complaints generated the inspection, and the inspection resulted in the authority having jurisdiction, witnessing firsthand commercial activity. That's his testimony. And the pictures suggest that there's commercial activity there.
And that's just not to cut you off.
No, that's fine.
But that's where I'm pointing back to the previous decisions in that. I'm saying if you go back and review that decision and what was submitted.
Sure.
Those things were already deemed non-commercial activities. So if you look at the equipment that's present, and what's actually being cited right now, stripping away the extra allegations that.
I think the building commission was being very considerate in the previous decision. But nonetheless, so we have testimony of the person, the authority that would that has bearing on this. It's not relative to a complaint. He investigated, he observed 2 different occasions. This is a different matter, right? There was 2 vehicles that were contested previously. Now we're talking about the number of vehicles, staging of materials and equipment.
There is no number of vehicles, so it's possible. There is no number of vehicles.
But there's more trailers than there were. There's the enclosed trailer, there's 2 open trailers, the sanders, the plows. This is similar to previous, but it keeps getting more intense each time. In 23, I may have been a little too lenient in my interpretation, but the conditions are more intense now than they were then.
Yeah,
I mean, it's a bigger person.
So the business is expanding.
To me, it is, the uses.
and look, this happens, right? You know, small contractors were involved in there, you start small and you do stuff in your house, but at some point you grow up and bring that activity somewhere else.
It's not growing up, we are the same, it's only the matter of, I just get a different trailer or extra trailer to load the mowers, it's lightweight trailer. I cannot put this as a heavy trailer, right? And I need a dump trailer to dump material outside, because my business, I'm not like a Comcast guy or something, right? One truck and just go there and come back. And every day I got a different job and it needs a different tools.
So that you.
But I'm sorry.
I would argue that, you know, if somebody has a trailer on their property for residential use, whatever it's used for in connection with their home, and they use it at work, that doesn't automatically preclude them from keeping it at the property. What I'm saying is the commercial activity that's going on is offsite. This is, you know, just the fact that you're bringing work-related items back and forth isn't necessarily commercial activity. Under the bylaw, everybody does that.
I think there's a testimony of the building commissioner and the pictures.
I don't agree with that. That you're coming every day back and forth, you got a business going on.
Yeah,
It's bringing lawnmowers in and out, trailers, whatever you haul, fill, whatever, the business.
It's very loose interpretation or convenient interpretation of the regs that we're just bringing a suitcase back home or a briefcase back home because it's a tool of the trade. Right?
Well, that's the logical conclusion of where this goes to.
But you're allowed to bring a briefcase home, you're not allowed to bring excavators and backfill materials and building construction materials to and from. It's a staging, it's a contracting.
If that's the board's interpretation, it's the board's, you know, I respectfully disagree with that. You know, and there's not excavators coming back and forth, it's a pickup truck and a trailer. And there's sites that have been pointed out that have been tolerated by the town that are bigger than the one currently going on.
So
It seems like it's a,
We'll worry about enforcing that as well. The, and I see a skid steer, I presume that leaves the site.
Yeah,
that was present in 2023 when the board decided there was no commercial activity going on.
and also this one, it moved from November, it comes back in April, it's never been there. Another trailer has never been there, so we moved it away for too long time, we just bring it back, and when Mr. John came back, I told him, sometimes we bring the stuff, we just park it, then we take it back. Most of these is not there, so this is, I never use it, outside except on the winter time, because I just use it in the winter time.
Presumably or something, or
Yes, so
that's nothing wrong with that. It's a contracting.
it's not moving every day outside. Yeah, I'm just telling you, it's my stuff was been the same like the first time. It just, Mr. John, when he came back, he found a lot of fill. This fill, he came back after 3 days. I get the fill the winter because there is some people, I know them, they're digging a big area. And I got it to re-level my backyard, right? And when he came back after a few days, he found everything on the ground. Another word, you said material. This material, I use it for the garage. I use it, there's paper there. I have a walkway and I show Mr. Erickson everything there. This is the only thing worked. I didn't have anything to sell. I didn't have anything to buy. I didn't have anything to store. Just a few woods extra of the garage that I built. A few extra papers from the walkway that, and I have the picture. We took some pictures. Those pictures was messy. Yeah, we cleaned the yard. We took the ballot out. It's not big. It's a ballot. Like, I don't know why reason for picture for ballots. We cleaned it up and there's nothing there. I can show you the new pictures. It just,
Well, I understand that, but the point is, at the time that the commission observed, you know, the site on numerous occasions.
but we explain everything right now.
I don't know if that's a permitted landscape is permitted use for home operation.
It's not a home
Occupation.
use. It's doctors, lawyers,
Yeah.
professionals, architects, right?
And we're not making an argument that
No, that's just a size of
there's no occupation.
There's many companies doing the same thing.
Well, we have no reason to refute the building commissioner's testimony, and observation and physical evidence, photos and notes. Is there anybody else in the to speak before we? Ultimately, we're gonna end up continuing this. We're gonna consult with council, but you've got a lot of case law, forward here that we just saw recently. Just to make sure we're taking the correct position, to be fair, right? To be fair. Not trying to persecute anybody, not trying to hurt you, but it's a two-family property, multi-family property, in a residential district. It's not, and yet there probably are other sites that need enforcement. We agree, we understand that, we're doing everything we can to fix them up, but
The way I see it, with a home business and you're growing, which is good.
There's no problem, sir. I just explained that I used a different trailer, like Mr. Erickson complaining about trailers. I used them in different
But if you
uses.
get different trailers, then it's growing with more.
It's not growing. If you please look for the picture.
yeah, so,
If I may, can I just get the contact information for town council, just so I can reach out and,
yeah,
so he knows.
we can, once we make contact with town council, we'll.
Thank you.
Did you want to say?
So are you continuing for another hearing, sir? Or are you continuing it, or are you simply waiting to have town council give you a legal opinion and then render a decision?
We're gonna wait, unless you want to take action now, I think it would be appropriate to get some.
Yeah, I think we should hear from the town council.
So do you want to continue it to the next scheduled
Continue
meeting?
to the next meeting. Or whenever she the bill.
Yeah, she just made aware of it today.
The next scheduled meeting would be November 20th.
So we'll definitely for the next meeting have. And I don't know if she'll provide feedback prior to. Sure, but we can give you some feedback to. For the next meeting.
Thank
you. If we can, I don't know if we can.
So we should make a motion to continue until November 20, the next meeting. Inviting me to hear back. We don't hear back to those.
Yeah.
Change the date at the time.
Second. See, raise his hand. Is he still there? Great.
I can make a motion to continue the hearing to November 20th.
And. So you want to second it with the raise? Great. All in favor of continuing the hearing? Roll call.
John, I.
Clark, aye. Yeah, he's
Just
confirmed.
I'll wait, if it's more close now.
Yeah. Okay, so the